Hello everyone, welcome to this session on Swayam platform, the online course on understanding competition law theory and practice. I am your instructor and we will discuss and we are continuing discussing. Today's the lecture 3 of this module week 2 and continuing 8th lecture on which we will discuss our deliberation on Monopolistic and Restrictive Trade Practices Act. The objectives of today's session is to discuss the salient features, aim, objective of MRTP Act. So, we're dealing with this act, that means Monopoly and Regulatory Trade Practices MRTP Act. We can have a snap of the previous lecture, and if you try to remember in last lecture what we have discussed, the ancient Indian law, the ancient Indian system and the legal provision, where legal provision or not legal provision, they are basically the social provision. But yes, in current regime, the legal provision what we are dealing with consumer law, there were some practices, some customaries and the customs and provisions which deals with consumer welfare. So in last lecture, we have dealt with the Vedic period, which was the spanning between 1500 BC to 500 BC. It was a very significant era in Indian history or Indian historical system. During this time, the Vedas, particularly the ancient scripture, were composed, and these texts having the text related to the social, economic and other welfare related issues. And among these issues, one or more issues which were very much related to the consumer welfare and welfare of the public, regulation of trade, regulation of the traders, which was basically related to the traders, sellers, how to regulate the trade and how to regulate the anti-competitive practices, unfair trade practices. There are certain principles which were in our ancient text, but to find out the actual provision, we have taken in last session the Manu Smriti as a context and the Arthashastra Kautilya as a literature where we can trace the relation of the modern law system and what were the principles in that time. And we found that there were particularly 2 or 3 basic aspects on which the consumer law or the relation of trade was governing, and which was protection of consumers, quality control and fair price. In last session, what we have discussed, the Atharved which have the provision which mention about the need of honest trade and condemn cheating. For example, if you remember the Arthashastra that a merchant who cheats in weights and measures and one who falsely represents the quality shall be punished. That means there were the system of punishment like what system in our modern competition law in section 27. The provisions related to the principle related to the quality control in ancient system, where if you see the Yajurveda which highlights the quality control, which mentioned that merchants should ensure the quality of their goods, which state the merchant who sell adult food shall be punished. And just like in fair price, the advocates fair price and mentioned that concept of just price, the price must be fixed according to their quality and standard. So with this, we are continuing with this today's session, which is related to the salient feature of the MRTP Act 1969. This is pertinent to know what were the reasons for the purpose of MRTP Act 1969. That means MRTP Act 1969, if you see, it is the period after the independence. That means before independence, there is no any specific act which regulate as the regulation of antitrust provision. That means you can say it is the first regulation after the independence which is basically directly related to the antitrust law. So this MRTP Act which came in 1970, if you try to find out what were the reason for the MRTP Act, there were certain reason of the rise of MRTP Act. Basically the basic reason, the industrial policy of the government of India of that time, the principle what is in the constitutional norm and constitutional value. If you remember, in last week in first module, while discussing the constitutional values related to the competition law, we have already discussed that there were certain provisions like the what is given in preamble, socialist and sovereignty, where the issues, the moral and the values of the constitution, which reflect even in article 38 and 39, which is about the deconcentration of wealth or decentralization of wealth, there were the certain provisions or the basic objective which pushes the policies or trade policies of competition policies of that time, and there were certain so many reasons which pushes the enactment of this MRTP Act 1969. The Monopoly or Restrictive Trade Practices Act of 1969 was enacted to address several issues, among them which is related to the concentration of economic power, restrictive trade practices in India. At that time, due to the industrialization policy of 1950s, the wealth was highly concentrated, and which was against the social norms, economics norm, which was against the constitutional norms which provide the economic justice. So if you see what were actual the provision which was related to the enactment of MRTP Act, you can see like concentration of economic power. The Indian economy was experiencing a rapid concentration of economic power in the hands of few businessmen, houses and industrialists. This led to the concern of the potential for monopolistic practices and shifting of competition. The restrictive trade practices. Many businesses were engaging in restrictive trade practices such as price fixing, collusion and cartelization, which harmed consumers and stifled competition. The lack of competition. The Indian economy was characterized by the lack of competition, which led to inefficiencies and high price of consumers. The need for regulations. There were a need of regulation to prevent the concentration of economic power and promote competitions in Indian economy. Protection of consumer interest. The MRTP Act aimed to protect consumer interest by preventing monopolistic and restrictive trade practices that could harm them. So these are the reasons. There are so many reasons, but these are some important reasons behind the enactment of MRTP Act 1969, which raised the 1969 to push to, that means the government of India was, because of these reasons, have activated for the creation of legislation of the MRTP Act. The Act was passed by Parliament on December 18, 1969, and this Act came into the force from 1st June 1970. MRTP Act regulates three types of prohibited practices: restrictive trade practices, unfair trade practices, and monopolistic trade practices. The term restrictive trade practices, unfair trade practices, what we have already dealt with in first module. If you remember, while dealing with types of competition or ways of competition, we have discussed the fair competition and unfair competition. If you remember, while dealing with unfair competition, we have gone through the meaning of restrictive trade practices and unfair trade practices. We have already discussed the meaning of restrictive trade practices, which was given in Monopolistic Act, that is MRTP Act, and unfair trade practices through the lenses of consumer law, welfare consumer law, or Consumer Act 1986, or with the lenses of the MRTP Act. So we are not here again dealing with such a term definition or concept specifically, but toward forwarding, Nehru's policies because the Pandit Jawaharlal Nehru was the first Prime Minister of the India after getting independence. So the policies which was adopted, particularly in the economic segment, you can say the economic policy of India or commercial policy of India, the competition policy, you can say, was adopted by whether it was the market policy or industrialization policy, which was altogether, that was a economic segment or economic policy, because policy is a broad term which engages all these aspects. At the time, because it was the policy of Pandit Jawaharlal Nehru as a cabinet head prime minister, this was known as the Nehruan policies. So there we are using the term like Nehruan policies, which named after India's first prime minister Jawaharlal Nehru, focused on a mixed economy model that combined elements of socialism and capitalism. This approach led to the creation of the Monopolies and Restrictive Trade Practices Act of 1969, which was aimed at preventing the concentration of economic power and promoting fair competition. The purpose of the MRTP Act, if you see the MRTP Act, you will find the purpose that MRTP Act was enacted to ensure that economic system in India does not lead to concentration of economic power into few hands. Towards this end, emergence of monopolies was to be controlled and monopolistic and restrictive practices were prohibited. Because after getting independence, the scenario in economic field was like the industries, the market system was basically under few hands, few particular industrialists, particular businessmen. So the issue was there were huge concentration of wealth, the assets, property and economic property was under some hands. And on the other hand, if you remember what Article 38, 39 require, that there must not be centralization or the assets or economic wealth, and there must be decentralization of wealth. So with this issue where we were shifting toward the socialism, Pandit Jawaharlal Nehru straight come with the policy that there must be curbing of monopoly and there should be restriction of curbing monopoly. Whatever there are some lacuna because of the being a welfare state, or because being the state under the duty to take care of the people, it was required that there were certain industries, certain sectors which were under the hands of government itself, which were out of the coverage of MRTP Act. So specifically, we will see it in another part, but still you must know that it was an act which was to ensure the economic system which may not lead to concentration of economic power into few hands. This was the basic object. Towards this end, emergence of monopolies was to be controlled, monopolistic and restrictive trade practices were prohibited. So if you see the aim, there are two wing or twofold. The first is, it was the act just to control the concentration of economic power which was under few hands, and second thing, the prohibition of monopolies. With this objective, this act came, but the lacuna you can say, or the requirement of that time you can say, because there are certain reason because of the non-applicability of the act. So where the act was equally applicable to the all, that means in public and private sector? No. If you see, the MRTP Act did not apply to undertaking controlled by the government or which is owned by the cooperative society, formed and registered under central or provincial or state owned control by corporation. Means the basic objective of this act to prohibition of monopoly of the industry or the market, because there were centralization of the wealth and the market was in captured of few hands. So from we are shifting towards the socialism approach. So the idea was it must be prohibited, but the act came with the feature of prohibition of monopoly, but this act was not applicable on government, whether it is central government or state government or any industry or corporation of cooperative society which was under registration or registered under the state or any parliamentary act. If you go with the salient feature of the MRTP Act, you see there are three more important terms what we are discussing from since first module: restrictive trade practices, unfair trade practices, and monopolistic trade practices. These were in MRTP Act, and if you see the MRTP Act, the restrictive trade practice means which was given under section 2 subclause O, which defines the restrictive trade practices as trade practices that prevent, distort or restrict the competition. Again, section 3 of the MRTP Act, which prohibit restrictive trade practices and includes the price fixing, limiting production or supply, allocation market or customer or collusive bidding. That means restrictive trade practices which was restrictive trade practices was prohibited under this act. And what was the restrictive trade practices? Restrictive trade practices are such trade practices which prevent, distort or restrict the competition. And there was some restrictive trade practices which was defined by the act itself, but includes also the price fixing. That means fixation of price where traders, suppose company A and company B, are fighting for each other, fighting to achieve against each other for their commodity or price. At certain point, they come with each other and Mr. A said to Mr. B, hello, if the price is, if you are agree, we may not lower the price against such a specific price. That means they are agreeing to fix, not to decrease the price from certain amount. This is like the agreement of price fixing. So this type of price fixing, limitation, production, supply, allocating market, customer collusive bidding was prohibited under section 3, and section 3 prohibits restrictive trade practices. There was another term which is known as unfair trade practices. Unfair trade practices we have already dealt with, but we are dealing here with the salient feature of MRTP Act. So under MRTP Act, unfair trade practices is a defined term. It was basically the one of the unique silent feature of that time. The unfair trade practices was defined in the section 2 subclause U of MRTP Act, which defines unfair trade practices as practices that cause harm to consumer or other businesses. Again, section 36A, which prohibits unfair trade practices, and it's include false and misleading advertisement, bait advertisement and deceptive packaging. One more segment, or you can say the unique feature of the MRTP Act was monopolistic trade practices, and which was prohibited under the MRTP Act 1969. Monopolistic trade practices was practices which was given under section 31, but the definition was given under section 2 subclause H, which define monopolistic trade practices as that limit or restrict competition. So if you see the main provision of MRTP Act, whatever this was not a competition act, this was against the monopolism, or this was the act to curb the monopolistic approach or monopoly, but the object of this was basically promote competition, which was not directly promote competition, but because of this act was related to the curbing the monopoly, so this was called as the monopolistic and MRTP Act. But if you see the definition, you will find that it is about the provision or regulation against the instances which regulate, which restrict the competition. So section 31, prohibition of monopolistic trade practices, which includes predatory pricing, exclusive dealing, trying agreement. Consumer welfare and investigation and enforcement was another unique feature of this act. Both are very different. Consumer welfare or consumer protection is basically the object of this act by under which the act was rose or act was legislated. But to get this objective, to execute the provision or to achieve the objective of consumer protection, the problem is how the act enforce the provisions. So there was a commission which is known as MRTP commission as an investigating and enforcement agency. If you see the consumer protection, which is the objective of any antitrust law, the section 12A empowers consumers to file complaint before MRTP commission. That means for the purpose of consumer protection, there are certain provisions which were directly related to the consumer, and the prohibition which was the prohibited or practices or approach which was prohibited or restricted under this act, to get sharpen the edge, to get the execution of these provision, consumer are free to file a complaint under this act, and section 12A empower the consumer to file a complaint, and they are free to file the complaint to the commission, MRTP commission. And if you see the section 12B of the MRTP Act 1969, it is about the establishment of Consumer Protections Council. The enforcement agency or the investigating agency under the MRTP Act, like what we have the CCI under the Competition Act on this modern law, under MRTP Act there was a MRTP Commission. MRTP Commission, if you go with the Act, you will find there are certain there are the establishment related, the provision related to the statutory provision related to the constitution, composition, function, whatever. But as a silent feature, what we are discussing here, you must know only that as an investigation or enforcement agency under section 45 and section 44, this was the commission which is known as MRTP Commission. If you see the section 44, Section 44 empowers the MRTP Commission to investigate complaints and launch inquiries. And under Section 45, which provides for penalties including fines and imprisonment for contravention of this Act. If MRTP Commission is basically directly related to the Section 5, under which the character or nature of the MRTP Act was given. If you go with the Section 5 of the MRTP Act, you will find that establishment of the MRTP Commission was a quasi-judicial body to regulate the enforcement of this Act or to enforce the provision of this Act, which shall be regulatory authority to deal with the offences under the MRTP Act. Major function of the MRTP Commission is to inquire into and take appropriate action respect of unfair trade practices and unfair trade practices and restrictive trade practices. That means under MRTP Act, the basic object to curb the monopoly, to prohibit the restrictive trade practices and to prohibit the unfair trade practices, and this is for the purpose of the welfare of the consumer, which was the ultimate goal. That's why the consumer are free to file a complaint if they find there are certain practices which is under the Act is restrictive trade practices or unfair trade practices. For therefore, under Section 12A, the consumer may file a complaint with the MRTP Commission, and MRTP Commission, which is of regulatory body under the Section 5, the nature of this MRTP Commission was like the quasi-judicial body, was a body to empowered with inquiry and empowered to penalize or inquiry to enforcement. So under the Section 5, it works as a quasi-judicial body and empowered to investigate complaint under Section 44 and provides the penalties, imprisonment if any contravention against this Act under Section 45. There are certain provisions under the MRTP Act which was related to monopolistic, restrictive and unfair trade practices. Like under section 10 of the MRTP Act, the MRTP Commission is permitted to investigate into the matter related to monopolistic and restrictive trade practices. On being referred by the central government, the unfair trade practices have been laid down in section 36 of the Act. The Act also lays down a provision for a appointment of a Director General of Investigation and Registration to facilitate the inquiry carried out by the MRTP Commission as well as maintain records in relation to restrictive trade practices. The MRTP Commission received complaints from the consumers, trade associations as well as individuals either directly or through different departments of the government. The Director Central of Investigation and Registration investigated a case preliminary when a consumer files a complaint. He was then required to submit his finding to the MRTP Commission for further investigation under relevant provision of MRTP Act 1969. So this was the basic, you can say what we have discussed today was the basic attributes or character or salient feature of MRTP Act. MRTP Act since long served from 1969, that means it came into 1970 and to till the CCI as a judicial body or quasi-judicial body under the Competition Commission came in 2002. That means it serves a lot. So if you summarize with some judicial attitude or cases under MRTP Act, here we may discuss 2 or 3 illustrative judicial cases or judicial pronouncement which is about the enforcement of the Act, like Bata India Limited versus MRTP Commission, which was a case in 1980. It was actively involved in the manufacturing, that means the Bata company was actively involved in the manufacturing of different kind of footwear. The poor manufacturer essentially involved cobblers and other small scale manufacturers. The agreement between the parties restricted the small scale trader to only buy raw material and sold from the parties and dealer approved by Bata. After analyzing the agreement in question, the MRTP Commission took the view that the act committed by Bata were restrictive and monopolistic. So this was one of the famous and popular case under the MRTP Act of that regime. And again, one more case which has several impact, even this is the one of the reason to the enactment of the competition law, and the case was Cement Manufacturers Association versus MRTP Commission 1980. The fact was basically the Cement Manufacturer Association was accused of price fixing and other restrictive trade practices, and the MRTP Commission decides, and after investigation they found that guilty of order it to dissolve. The member companies were directed to cease and decide for such practices. And likewise, Hindustan Lever Limited versus MRTP Commission in 1988. The fact was Hindustan Lever Limited was accused of abusing its dominant position in the market for soap and detergent by fixing price and limiting production. Again, in this case, the MRTP Commission held the Hindustan Lever had abused its dominant position and ordered it to cease the decide from such practices. In 1994, ITC Limited versus MRTP Commission, where ITC was accused of engaging in restrictive trade practices such as price fixing and limiting production of cigarettes in market. The MRTP Commission found after inquiry that ITC is a guilt and ordered to cease the desist from such practices. Again in 1995, Mahindra and Mahindra Limited versus MRTP Commission, the Mahindra and Mahindra Limited was accused of abusing dominant position in markets of Jeep and other vehicle by fixation of price and limiting the protection. Again, Commission held that Mahindra and Mahindra has abused its dominant position and ordered to desist from such practices. So MIC, that is MIC drafted a bill to provide it for operation of economic system so as not to result in concentration of economic power to the common determinant. and this bill later became the Monopolistic Restrictive Trade Practices in 1969, and it came into the force on June 1st, 1970. The MRTP Act has its legislative root in DPSP, what we have already discussed in detail, so we are concerned only, I am reflecting the provision with you, the subsection of B and C of Article 39. This was the basic reason of the why MIC drafted the provisions or with the restrictive trade practices which may come. So the Article 39 B and C we have already discussed in previous classes. So you can say the primary objective of MRTP Act to protect against monopolistic trade practices, restrictive trade practices and unfair trade practices. So with this session is will take over in next lecture, where we will discuss the limitation and criticism of monopolistic and restrictive trade practices. Thank you.